Hello, this is Bench Basics Docket Management. I am Teresa Cisneros. I am a district court judge in the 4th Judicial District, which includes El Paso County and Teller County, and I am currently assigned to Teller County.
Hi, my name is Chris Bachmeyer. I'm a district court judge in Jefferson County in the 1st Judicial District.
Hi, I'm Kathy Delgado. I'm a district court judge in the 17th Judicial District, which is Adams and Broomfield counties. I'm currently assigned to Adams County.
Hi, I'm Candace Curtis, District Court Judge, 2nd Judicial District, City and County of Denver.
I've been on the bench since January of 1997, and I've had the good fortune of being able to manage every type of docket and every combination of docket. I was in El Paso County for 18 years. That is an extremely busy urban jurisdiction, and for the last year and a half, I've been in Teller County, which is a rural jurisdiction. I haven't experienced significant differences in case management between the urban jurisdiction and the rural jurisdiction. Some things that might delay rural cases are transportation issues, limited services, but docket management basically works the same. Since taking the bench, I have always had a policy that something meaningful should happen at every court appearance, and that court continuances are given sparingly and only with good cause. I determine whether there is good cause. In the 4th Judicial District, the county judges do the felony advisements only, and then the cases are transferred to the district judges for all other proceedings. I see the felonies at first appearance when charges are filed. The way my docket is structured is first appearances, bench warrant returns, appearance of counsel, and pleas at 9 o'clock in the morning, sentencings at 10:30 in the morning, and all contested matters at 1:30 in the afternoon. That includes preliminary hearings and motions. I only do a docket one day of the week. A lot of what I have seen that is effective docket management applies to both county and district judges. The following are my suggestions on how to efficiently manage a docket. First and foremost, it's really important to take the bench on time. The reason for that is that sets an expectation that court is important and you expect things to happen. Set an expectation that something meaningful happens at every court appearance. Let me give you an example. A defendant who is advised of new charges is told that he or she has to apply for a public defender within 48 hours following that person's release from jail. The 48-hour rule is designed to impress upon the defendant the urgency of getting counsel. For Teller County cases, that person can fax the application to the public defender's office, so the 48-hour rule can be easily accomplished. Inevitably, when a person comes in for first appearance, they haven't done that yet, even though they've had 2 weeks to get it done and were told to get it done within 48 hours. Rather than set it out another 30 days for them to apply, I set it out 1 week with an admonishment that they need to have a lawyer and they need to get the application submitted. That is usually enough to light the necessary fire under them to get that done. Set hearings or trials out far enough to give the parties or lawyers time to get done what they need to, but make it a short enough time to give them the incentive to get it done. Utilizing the example of the pro se defendant needing to submit the application to the public defender's office, human nature is such that if I give him 30 days, at day 29, he'll finally get around to getting it submitted. So shorten the time as a way to express the urgency of getting counsel. Set an expectation with the counsel and the parties that continuances are granted sparingly and only with good cause. If you find yourself regularly setting over cases because the lawyers aren't ready or they didn't do something they were supposed to, evaluate your own set over policy. Maybe their next court date needs to have more teeth, like setting a jury trial as opposed to one more dispositional hearing. Carefully monitor the reasons for the continuances. An example that frequently arises is, Judge, my officer is on vacation, I need a continuance. Instead of just routinely granting that because the lawyer makes that statement, ask what the officer is going to say that's so important, and ask whether there's another officer who will say the same thing. It may very well be that there is no need for a continuance, which is what frequently happens when you ask these types of questions. Call the docket rather than turn it over to the lawyers. Why? Because they will only call the cases they are ready on, and you will be taking recesses to allow them to work on the ones they weren't ready on. I call that the jack-in-the-box judge. If you picture that, that is, you come in, the lawyers say, we're ready on this, you take care of that case, you leave the bench, you come back again, you do it all over again. That's the jack-in-the-box judge. Avoid the jack-in-the-box judge by calling the docket yourself. Also, by calling the docket yourself, you set the expectation that you expect them to be ready on all of the cases, not just the ones they want to be ready on. When you find yourself granting continuances because the DA, quote, just made a plea bargain offer on Friday and I haven't had time to talk to my client, close quote, tell the lawyers that you expect the DA to make plea bargain offers timely enough to allow defense counsel to talk to her client. One of the problems that I've been encountering frequently recently is drive-by emails. What is a drive-by email? Those are the emails that the lawyers just sent out at the last second. They don't have a chance to talk to each other. They don't talk to each other. That always causes problems with docket management. Issue an order that they are required to talk to one another. Stop the drive-by emails. When you have lawyers, the public defender and the DA usually, who aren't getting along and won't talk to each other, you can first try to talk to them and tell them that you expect them to start working with each other. If their behavior persists, you can talk to their supervisors. Sometimes this is helpful, but frequently it is not. I think a more effective way to handle them is to order them to come to the courthouse, set them up with the room, and order them to stay and talk to each other about all of the cases on the docket for the next coming docket until they have gone through every file. Don't let the lawyers dictate in which order the cases go to trial, especially when you have lawyers that aren't getting along. If you allow them to dictate which case goes to trial, that eliminates their incentive to resolve the other cases because they know these other cases will just get kicked over to another day. And so you let them know on the day of trial, if you haven't worked them out, I will let you know in what order they go. I guarantee you they don't want to spend all their time preparing every single case for trial. That gives them incentive to resolve the cases. Don't set meaningless court appearances. An example of this is a pretrial readiness hearing where parties announce ready for the trial at the pretrial readiness and then realize on the morning of trial that they don't have their main witness. Instead, at the pretrial readiness, ask them questions that are pertinent to determining whether they really are ready for trial. Examples: do you have your witnesses under subpoena? This again reinforces to them that you expect something meaningful to happen at every court appearance. When the lawyers tell you they aren't ready because they haven't talked to a necessary person, rather than just setting it over to another day to allow them to do what they should have done already, have them try to contact the person at that time. Put the case at the tail end of the docket, take a break, and have the lawyer call the person. You can probably avoid setting the case over just by doing that. Have your staff run an open case report each month at the end of the month. Compare that open case report to the prior month and determine whether your caseload is increasing, decreasing, or staying the same. Have your staff run an age of case summary report. That's the statistical timeline report, which will tell you whether you're meeting the benchmark set forth in CJD 0805. When actually calling the criminal docket, organize the docket ahead of time into quick matters, not so quick matters, and long matters. Call the quick matters first. When you have a courtroom full of people, the more you can get out of there quickly, the more manageable it is and the better you will feel. Trust that the lawyers will rise to whatever standard you set.
I preside over a mixed docket that consists of approximately 125 criminal cases, 75 civil cases, and 50 domestic relation cases. We have 8 county courts in Jefferson County. They conduct the preliminary hearings on all of our felony criminal cases. Once the felony charges are bound over to my district court, our division schedules an all-day criminal docket on alternate Mondays. We typically see between 60 and 80 cases set for arraignments, pretrial conferences, sentencings, probation revocations, and advisement of charges. My procedures for criminal case management on docket days are well known to all of my attorneys. I try to have a lunch twice a year with the attorneys to discuss the docket management, discussing what works, what doesn't work, and to suggest better ways to manage our heavy dockets. I agree with most of Judge Cisneros' comments, so I'm not going to repeat them again. Because I have a mixed docket, the major difference is how we set our criminal jury trials. Our criminal docket will start at 8 o'clock, priorities given to the in-custody defendants and the interpreter cases, and then to private counsel. I generally allow one continuance of the arraignment for good cause, or the defendant enters a not guilty plea. If the parties convince me a plea is imminent, I set the matter out for pretrial conference about 2 to 4 weeks out. If the parties are unsure if the case will plea, I set the matter 2 to 3 months out for motions and order the parties to appear on the Monday docket before the motions hearing for the court's dispositional deadline. If the case does not plead at the dispositional deadline, the matter proceeds to the motions hearing. After motions are then heard, I set a jury trial about 2 months out. Because most of the cases plead at or before the dispositional deadline, we have few criminal jury trials set, and rarely have speedy trial issues. Generally, trials set on the court calendar go, barring an emergency, or the defendant pleads to the lead charge. This system is critical in scheduling our civil and domestic matters, as our docket is not clogged with jury trials that would usually plead.
I currently preside over a criminal docket. I agree with Judge Cisneros' best practice procedures. However, it is important to understand the culture in your own jurisdiction and adjust the procedures accordingly. In Adams County, there are 5 criminal divisions. The county courts conduct the preliminary hearings on all felony matters, with the exception of first-degree murder cases. Jury trials are scheduled at 9 a.m. on Mondays and Wednesdays. Pretrial conferences are scheduled the Wednesday before the trial. It is common practice to set multiple trials on those days. All 5 criminal divisions set arraignments, probation advisements, and sentencing hearings at 8:30 a.m. Monday through Friday. When a division is in trial, it is fairly common that another division will cover the 8:30 docket in order to start the jury trial at 9 a.m. Motions hearings are set on Fridays. I often allow continuances of arraignments when the prosecution has made a new offer on the arraignment date or defense counsel has just entered and has not received discovery. Often, defendants who have been in custody at the county court stage and have bonded are ordered to submit an application to the public defender's office, and I will allow a 15 to 30-day continuance to determine if the defendant qualifies for court-appointed counsel. I order the defendant to submit an application immediately after court. I allow defense attorneys to call the docket with the exception of the pro se defendants. Priority is always given to interpreter cases and in-custody defendants. It is my practice to meet with the district attorneys and the public defenders assigned to my courtroom on a regular basis to discuss any issues or concerns I may have, as well as that they may have. They are informed that I expect everyone to be ready at 8:30 a.m. when I take the bench, to raise pretrial motions at the pretrial conference and submit proposed jury instructions at the pretrial conference.
I currently preside over a criminal docket. I agree with the best practice procedures outlined by the other panelists. In Denver, there are 8 criminal divisions. The county court conducts the preliminary hearing on all felony matters with the exception of first-degree murder cases or cases where the defendant has failed to appear at a second advisement. Felony jury trials are scheduled at 8:30 a.m. on Mondays and Tuesdays. It is common practice to set multiple trials on those days. All 8 criminal divisions set arraignment, probation, advisements, and sentencing hearings at 8:30 a.m. Mondays, Thursdays, and Fridays. I do allow continuance of arraignments on the first appearance after the case is bound over, or if defense counsel has just entered and not received discovery. If a defendant has bonded after the case is bound over, I require as a condition of bond that the person apply to the public defender's office and set the person over for 7 days for them to complete the application and bring their paperwork back to court. At the arraignment, I set the case for trial, even if there is a likelihood that it will ultimately dispo. I usually grant 21 to 28 days for filing of motions. I set a pretrial conference at the disposition date, and my pretrial order does not allow for late dispositions except on a showing of good cause. I allow the attorneys to call the docket with the exception of pro se defendants. Priority is given to interpreter cases and in custody cases. If the attorneys are prepared prior to 8:30, I will start docket early. It is my practice to meet with the district attorneys and public defenders assigned to my courtroom on a regular basis to discuss issues or concerns. I find out their concerns or comments, then share with them my observations as to how we can be efficient with the use of everyone's time, especially on docket days. It is very important that the attorneys communicate with each other and that they have respect for and communicate responsibly with the courtroom staff. Thank you.